Welcome to the Miller Report. I'm Maggie Miller. Today we're tackling an important question raised in Ben Weingarten's recent RealClear investigation. Can a single judge unilaterally thwart the President of the United States? That's a question the Trump administration is now asking the Supreme Court to decide. RealClear Investigations examines the surge in universal injunctions, orders from federal judges that block policies nationwide. This tactic has skyrocketed, with 15 issued in February alone, more than the total from President Biden's first 3 years in office. Critics say this gives individual judges too much power over national policy, while supporters argue it's a vital check on executive overreach. So far, the Supreme Court has been silent, leaving the country in legal limbo. The practice of universal injunctions was rare before Trump's first term, when progressive groups turned to the courts to block his policies. Now we're seeing it again in his second term, most recently with a judge halting the deportation of members of the Venezuelan gang Tren de Aragua using the 1798 Alien Enemies Act. Critics say this is a case of judge shopping, picking sympathetic judges to get the ruling that you want. Both parties have used this tactic in the past, but the Trump administration says it's now being abused to block his most basic executive actions. Other recent universal injunctions are aimed at Trump's birthright citizenship executive order and DEI initiatives. Congress is taking notice. California Republican Darrell Issa has introduced the No Rogue Rulings Act of 2025 to the House Judiciary Committee. This bill would ban district courts from issuing nationwide injunctions unless a case is brought by 2 or more states from different circuits, in which case a 3-judge panel could approve one. The bill passed out of the committee with bipartisan amendments and is now heading to the House floor. Meanwhile, Chief Judge James Boasberg of the D.C. District Court blocked Trump's deportation order against the gang members. Now he's facing articles of impeachment, announced on social media by Republican Representative Brandon Gill of Texas. If filed, Boasberg would become the 4th judge this year to face impeachment over universal injunctions. President Biden, interestingly, has also previously criticized the growing use of injunctions, even as his policies have sometimes benefited from them. But this raises a bigger question. How do these injunctions affect foreign policy? Can a single judge overrule the president on national security? We're joined now by RealClear Investigations Ben Weingarten to discuss what this means for Trump policy and decisions moving forward. Ben, thanks for being here.
Thanks so much for having me.
So obviously, the big question is, how do we get to a place where a single district judge can hold this much power over national policy? And what happens when a judge's decision has to do with national security?
Well, it's really been a remarkable evolution in the way in which judges preside over cases. And historically, and the way most people understand the presiding judge's job, is that they rule on cases and controversies concerning the parties before them. So in the case of a presidential administration, the relevant agencies or the White House versus litigants. And in the case of the first Trump administration and now the second Trump administration, sometimes blue state attorneys general or attorneys general representing blue states, NGOs, those who worked in the government and beyond. And really, the notion of universal injunctions, which are when a judge puts down an order, and they have different names depending upon where they're imposed in a case, but they put down an order prohibiting an administration, for example, from engaging in certain acts, enforcing a policy, sometimes preliminarily before a case develops, sometimes during the pendency of the case, which is a preliminary injunction, and then at the end, potentially a permanent injunction, freezing a policy in toto. They do that to protect the plaintiffs in the case who allege that they are being harmed. And with universal injunctions, the thing is that everyone, no matter where they're located, becomes a protected plaintiff. Even people who don't want to be protected by an injunction, and even those, of course, who live, reside, or work in jurisdictions well beyond the bounds of the judge's jurisdiction. And so some have dated the first initial universal injunctions to back in the early 20th century. Others say around the 1960s. And if you look at the way that they've been imposed upon presidents, they were very seldom used, really dating up until the first Trump administration. And critics of President Trump will say that they were imposed at mass scale under his first presidency because he was engaged in overreach, the likes of which had never been seen before. And those on the other side will say that this was a remedy that was used by judges who were acting in a more radical or zealous fashion than ever before. And the numbers are pretty staggering. If you look at all universal injunctions issued against presidents, ordered on presidents between 1963 and 2023, more than half of them were ordered against the first Trump administration. And in just the first 6+ weeks of this administration, and actually in February alone, there were more universal injunctions imposed on President Trump than during the first 3+ years of the Biden administration. So the numbers are staggering. And to get to your last point on national security, we're going to see these issues adjudicated in the court, but at a very basic level, the president, as commander in chief, may have limited authorities or powers, generally speaking, that is, the executive branch. But in matters of national security and foreign policy, the executive is the commander in chief, and he has very wide latitude, in no small part because the founders wanted a president who could vigorously execute his duties in matters where the powers needed to be concentrated and the decisions needed to be made in one person. And so, of course, when it comes to matters like counterterrorism, when it comes to repelling invasions, and I'm alluding here, of course, to this Tren de Aragua controversy that's blowing up just as this story was going to be published, what this is putting to the test is whether or not judges can essentially micromanage even down to missions like flights deporting designated terrorists, whether a judge can order those flights grounded, can order they be turned back, to the extent he issues a universal injunction freezing a policy under which they're being deported, even when the statute appears to be very clear cut, as it was in that particular case. Is this a justiciable issue or not? That is a court a proper venue to litigate over a matter like a counterterror policy like this? Or is this really an expressly political matter that is about the executive's authority? And if he wields his authority in a way that our representatives believe is legitimate, fine. And if not, then the legislative branch has all manner of powers that it can use to check a president that it thinks is acting either lawlessly or recklessly or not in America's national interest. And of course, that includes the power to make laws, the power of the purse, and impeachment powers as well. And I think we're going to see a clash very shortly, and it's already bubbled up, and my piece covered this in part, between all three of these branches about what is executive authority, what is the proper role of the judiciary, what are questions that are political questions that ought to be left to the executive and legislative branches, and to what extent, if lower courts are overreaching, will the Supreme Court step in or the appellate court step in and rein them in? Or is it going to be a matter that's left to our representatives in the legislative branch?
So obviously you mentioned the Supreme Court and how they might have to step in and make a decision. You know, the Trump administration has been asking to see what they're going to say. Do you think they'll avoid the issue again, or what happens in the interim while they haven't spoken out on it?
Well, in real time, as we're recording this interview today, President Trump has come out and called for the impeachment of Judge Boasberg presiding over this Tren de Aragua controversy. And this comes on the heels of articles of impeachment being filed against Judge Boasberg. And as I detail in my article, 3 other judges as well who have been imposing these injunctions on the president that he perceives as lawless. And Chief Justice Roberts himself, in a very unorthodox statement, issued a statement, terse one, saying that impeachment is not the appropriate remedy and that these controversies can be dealt with sort of through regular order via the appellate process, which the administration has been following to date, despite being thwarted by any number of judges who have an adverse view to any number of policies. Chief Justice Roberts speaking here, I think, may be telling in terms of what comes later at Supreme Court. Some of these controversies are certainly going to be dealt with at the appellate level. But the very fundamental question, setting aside whether judges are overreaching in the lower courts and whether those cases will bubble up ultimately to the Supreme Court, is this issue of universal injunctions. Are they legitimate or not? That is probably the most significant manifestation of alleged overreach from the lower courts. The Trump administration has put forth a filing with the Supreme Court calling on it to stay, which is to say freeze, several universal injunctions imposed blocking its birthright citizenship order. And in their filings, which are pretty much identical in these three cases, the administration talks about the fact that universal injunctions have all manner of detrimental impacts to them, are dubious from a constitutional perspective. The likes of Justice Thomas and Gorsuch, not to mention Justice Kavanaugh, have all said the court is going to have to rule on the legitimacy of this remedy at some point in recent years. Justice Gorsuch, incidentally, back in January of this year, in a case brought by the Biden administration, calling on the Supreme Court to rule on their legitimacy. So the issue is coming to a head right now. And you also have the legislative branch not only talking about impeaching purported rogue judges, but also putting forth legislation to curtail universal injunctions. So with the threat of legislative action, with all the scrutiny being put on the courts, Chief Justice Roberts' response was not to remain silent and act aggressively to the extent lower courts are overreaching. He said we need to maintain regular order. We need to let the cases bubble up. So we can read the tea leaves. Maybe that's suggestive of where the court will ultimately go on universal injunctions. Maybe it's not, but the court seems content to let these cases continue to play out.
For context, Chief Justice Roberts said, quote, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to the disagreements concerning a judicial decision. The normal appellate review process exists for that purpose." So just to provide that context there. Now, do you think that the rise of impeachment articles against judges is a sign of much needed accountability, or is this kind of a dangerous politicization of the judiciary?
Well, those who I interviewed in connection with my story who have drafted some of these articles and set up a task force in Congress to expose what they perceive to be rogue judges way overstepping their authorities, they will tell you that they believe it's their constitutional duty to hold a judiciary that acts lawlessly to account in order to ensure and maintain the legitimacy of the judiciary and, of course, the rule of law. Those on the other side will counter that we shouldn't go about recklessly trying to impeach judges, or they'll say that setting aside the merits of using that remedy or not, ultimately these judges are not going to be impeached and removed. The votes simply aren't going to be there. This is grandstanding, etc. So you have a clash within the legislative branch about what they think their duty ought to be and how they ought to respond to hold judges accountable. On sort of the lesser remedy of curtailing universal injunctions, a bill to do just that has passed out of the House Judiciary Committee. It's headed for the House floor. Darrell Issa was the lead sponsor from California, Republican from California, on that bill. He told me he is confident in an interview that that will pass the House, and we'll see what happens in the Senate. Senate Judiciary Committee Chairman Chuck Grassley, as I also detail in the story, told me in a statement that his committee is going to seriously look at reforms with respect to nationwide injunctions. And he also drafted a letter last week commending the Trump administration for issuing a memorandum demanding that in all of these cases where injunctions are at play, the administration lawyers must demand that the plaintiffs put up injunction bonds, with the idea that this will deter frivolous cases, the demands for overly broad injunctions, et cetera, because there'll be risk then to the plaintiffs that you have to put up substantial sums to defend against the case where you're going to prohibit the administration from doing something against anyone everywhere in any number of policy contexts. So it seems like there's real legislative action here to try and rein in the judiciary. Maybe that's ultimately going to prove posturing that tries to force the courts to jump. But it does seem that there are real legs for legislative reforms. And whether or not that leads to impeachment, I think is yet to be seen. We've yet to see anything maybe beyond the pale in the eyes of members of Congress, beyond what Judge Boasberg has done. But I think you're going to continue to see calls, and those calls continue to ramp up as judges issue opinions and render orders that seem to be more and more unmoored from their duties to preside over cases and controversies between discrete litigants.
And so you mentioned Issa's bill, and I know that Trump would likely still argue that this is a limit on his presidential power. But do you think that that would reshape the balance of power and kind of create a middle ground? Because obviously, there's people who are saying, leave it as is. He should be able to make whatever decisions he are, and other people are saying, these universal injunctions are really important. So is this the middle ground?
I think to some extent, the Supreme Court could render this all moot by itself ruling on the legitimacy of universal injunctions. And we'll see if that ruling comes down, and it's almost certainly going to come to a head in the near term, probably, certainly under this administration. And one of the reasons that there's so much ambiguity here and a lack of clarity is that the appellate courts across the country have all come to different opinions as to the legitimacy of universal injunctions. And so usually the Supreme Court will step in when you have these conflicting opinions from different appeals courts and come up with a uniform response. So is this a middle ground? Basically, what the legislative branch is saying is we created these Article 3 courts. We oversee them to some extent, and we can make laws that to the extent they're overreaching and to the extent they're trampling or usurping the authority of the executives, putting at least a 3-judge panel in place to make a decision when there might be a real more legitimate grounds for calling for a universal injunction, like when there are multiple states who are bringing a case, for example, on a practical level. The idea is, well, let's have a 3-judge panel rather than a single judge out of 700 make a determination, and then that can be appealed very quickly to the Supreme Court to help deal with these cases in a more rapid manner. But otherwise, when it's individual plaintiffs and when it's not that exception, the idea is that there shouldn't be universal injunctions because judges are supposed to rule on the litigants before them. The Supreme Court, rather, the Constitution is silent on the matter of universal injunctions. And there's debate over whether there's anything in statute which says that universal injunctions are lawful. So, given that the law may be silent or at best ambiguous on it, codifying that outside of that one exception, there can be no universal injunctions. I think the legislative branch thinks it's doing its job. To the extent it's a middle ground that would have very wide-reaching ramifications when you consider the rate at which federal judges are enjoining the president via these universal injunctions and the scope and scale of the universal injunctions as well.
Definitely an interesting point. And obviously, when talking about the Judge Boasberg, who made the Tren de Aragua decision, how often has his judgments been upheld in the past? Do you have that information?
So I can't necessarily speak to the full record of Judge Boasberg in terms of has he been slapped down a substantial percentage of times on appeal, including potentially appeal up to the Supreme Court. But what I can say is that he's been involved in a whole slew of very controversial cases. And in some ways, he's like the Forrest Gump of controversies that we've seen bubble up between the executive branch, in particular Trump world, and the judiciary as well.
So, to kind of wrap things up a little bit, what reforms, if any, do you think would strike the right balance? Obviously, between checking executive overreach and preventing judicial overreach, how do we move forward from here?
Well, one thing I would say at the outset is that the Constitution, properly understood and properly interpreted, I think holds all the answers that we need to any number of these controversies. And I think it's notable. In the first Trump administration, the resistance to Trump primarily existed within the administrative state, which critics would say is a fourth branch of government not called for in the Constitution, consisting of unelected and unaccountable, ultimately, bureaucrats. And they essentially operate as they're going to operate, pursue their prerogatives, irrespective of who the executive is. And so resorting to resisting a president, via the national security or intelligence apparatus in that way takes these controversies out of the hands of the public via their elected representatives in the legislative branch or the courts potentially. Now, this time around, you have the Trump administration, which knew that the administrative state would potentially be an Achilles heel again, seeking to reassert true executive control over the executive branch. And that's in terms of personnel and in terms of policy, and trying to pursue a very ambitious agenda very rapidly. And in response to that, this time, The resistance is fighting at the courts being a genuine third branch of government, legitimate third branch of government, but which itself also consists of unelected judges. And so what you see now is there a way to hold those judges accountable ultimately? Does the administration seek out sanctions when they think a judge has really overstepped their bounds and acted in radical fashion? Is impeachment a remedy? This memorandum on injunction bonds, is that a way to deter frivolous suits potentially and shrink and ensure that the injunctions are tailored to the actual plaintiffs in the case? And I think, look, universal injunction reform, that is curtailing them via the law, I think is probably the single most substantial remedy that you're going to see outside of impeachment. And obviously, with impeachment, you have risk of massive political backlash. One of the reasons why it's a tool seldom used. And we've had very few judges in our history impeached, federal judges impeached, let alone removed. So, in terms of striking the right balance, it requires every branch lawfully asserting their authorities and exercising their powers with due discretion. And we have all of the checks and balances built into the system. The question is, if one branch acts as if it's usurping the power of another branch, what is the remedy then? And we're seeing that on both sides now. The judiciary thinks one thing, the executive and the legislative branch thinks another. And so our system is durable. Our system has endured any number of massive controversies throughout its history and survived. But this is putting it to the test right here. In part, I think, because you're seeing a president trying to assert his authority over the executive branch that really hasn't been seen in the 100+ years since the advent and original explosion of the administrative state. And of course, you have massive entrenched interests who want the status quo to be maintained. And as a consequence of that, you're seeing massive controversies break out between all three branches of government. It's a historic time, and we'll see if it's a time that ultimately leads to a government that is more responsible, a government that legitimately and faithfully follows the Constitution, or if it's going to lead to more dissent, more chaos, more hyperpoliticization, weaponization down the road.
It's a difficult balancing act because obviously you think of judges as umpires, but these umpires haven't been elected in many cases, and they might, have some outside influences. So it's interesting to see how it's all going to play out and get worked out. And I guess that's a question for a future report for you.
Exactly right.
So anything else you'd like to add as we wrap things up?
These matters are exploding in real time, and I would say follow me on Real Clear Investigations for future reporting on the controversies between the three branches. And you can keep up to date, up to the minute with my work on X at BH Weingarten and via my Substack mailing list at weingarten.substack.com.
Perfect. Well, Ben, thank you so much for taking the time to speak with me today.
Thanks for having me.
That's it for the Miller Report. We'll see you next time.